It's not to have any of my time started yet. I actually, other than the comments that we just heard, I don't think any of other Mrs. Drumheller's questions were answered. She had some questions. You said list them all off and we'll answer them at the end, but I don't think any of the other ones that she said were.
Well, we still have our public comment, or we still have our municipal comment.
So you're going to wait till we're all done and then answer her questions and mine, like all at once, or?
If we can get to them, yes. If we have the answers for them, yes.
Okay, so you've written them down. Okay,
yeah,
so then,
I have notes here.
Okay, then I'm just going to. So my questions will basically be just to kind of follow up on hers with a few more details. So essentially, it'll be some of the same questions, but with a little more detail. I'll address 2 points for time's sake. One is, once again, on rights of way. The idea of a public right-of-way our question on that is, once again, it's a public right-of-way for public utilities. So to give it's not. I see somebody shaking their head. So let me give you an example, and maybe you can answer this question when you do answer our questions. Let's say that. My neighbor, something that's as innocuous as you can think of. Let's say my neighbor wanted to put up a lemonade stand, and we found out that the public right-of-way, my yard is the 10 feet that Mr. Hugas was saying because of, just estimating, we don't know exactly. But in that 10 feet, if my neighbor wanted to put up a lemonade stand, I mean, nobody's really going to get too uptight about that, but let's say I just don't want it there. If the council says, go ahead, is that a proper use for a private business, even if they're going to make $1 that day? I'm not talking about amounts of money. I'm just talking about a private business. It's not a public utility. It's not the gas. It's not the water. It's not the electric. Is that what the public right-of-way is for, even if it's the most innocuous private business? We're not talking, obviously, I don't think that the seismic testing and the drilling is an innocuous business. But I'm trying to just make a point. So I'd like that answer. Maybe I'm not aware that somebody could. If they came and said, can I put in Mr. Mintz's front 10 feet of public right away, I could sell something I made at my house. I could, I'm a knitter, I'm a whatever, whatever. You understand what I'm saying? I'm going to squeeze lemonade. Can they do that because you said it's okay, even though that's for the utility? So that's one question. I don't know if we're going to save them up, if that's the case. Okay, so that's one question. My other question really, the idea that our council, I think generally, it was unanimous, agreed that we were going to put this cease and desist order. Geokinetics obviously disagreed with the cease and desist and continued their operations. And so per that idea that they continued the operations, and the idea that in the proposed letter that Lois read, actually I'm going to read, and it won't take much time. It's just a few sentences here. It's a couple paragraphs. It is exactly from the 10K form that Geokinetics submitted to the Securities and Exchange Commission. Now, already, just to reiterate, our council said that they were not abiding by our agreement of November 22nd. Told them to stop. They just didn't. They sent us a letter from the lawyer saying, we're not going to stop because we don't think we're violating it. And they did their business. Okay, now that they've done their business and collected their data, well, according to them, once again, I'm going to read this so everybody at home understands this. It says, this is the 10K, this is what a company has to send for its stockholders to understand before you're going to, like if you read a prospectus, if you're going to invest in a company, you want to know what risks you're putting your money into, right? And so the company has to explain this. This is from Geokinetics for their stockholders and through the Securities and Exchange Commission. Our operations are subject to delays related to obtaining land access rights from third parties which could affect our results of operations. Our seismic data acquisition operations could be adversely affected by our inability to timely obtain access to both public and private land included within a seismic survey. We cannot begin surveys on property without obtaining permits from certain governmental entities, as well as the permission of the parties who have rights to the land being surveyed. In recent years, it has become more difficult, costly, and time-consuming to obtain access rights as drilling activities have expanded into more populated and protected areas, like Monroeville. I added that part, obviously. One more paragraph. Additionally, while landowners generally are cooperative in granting access rights, some have become more resistant to seismic and drilling activities occurring on their property and stall or refuse to grant these rights for various reasons. In our multi-client services business, we acquire data sets pertaining to large areas of land. Consequently, if we do not obtain land access rights from a specific landowner, we may not be able to provide a complete survey for that area. The failure to redact or remove the seismic information relating to mineral interests held by non-consenting third parties could result in claims against us for seismic trespass. In addition, governmental entities do not always grant permits within the time periods expected. Delays associated with obtaining such permits and significant omissions from a survey as a result of the failure to obtain consents could have a material adverse effect on our financial condition and results of operations. If you understand why I read that, is that's the risk that somebody's taking when they invest in that company. But they're laying out the idea, not the idea, but they're laying this out in a legal form that they need to obtain those rights from the third party. So even if Monroeville, and this all pertains to both of my questions, Monroeville granted the right to use our public right-of-ways, whether, and I still need to know whether that was okay or not because they're a private business, but let's say we determined that it is. I don't know that that's true. But if it is, still, when they did the seismic survey, they went under each owner's land. Some owners may not have rights to that land, to the data that can be collected from under their property, and some owners may have the rights to the data that is under their property that's being collected. Did geokinetics go to each landowner and find out who has that right to that data and who does not? And especially, and this is why I brought this up first, especially after Monroeville said cease and desist, they just said, we think we're okay. We don't agree with you in saying that we're violating the agreement. We're just going to continue to do our work and finish it and go on our way. Now they have data that not only did you think that they shouldn't have been collecting because they weren't agreeing with us, but according to their 10K Securities and Exchange Commission legal statement, were they finding out from each landowner that they have a right to collect that data and use it for their own private business? And if not, it needs to be redacted. They said so. This because otherwise they could be resulting claims against us for seismic trespass. So Monroeville or each landowner could make claims against them for seismic trespass. So, I don't know if this has to be done by each landowner or Monroeville itself, but here we are hoping that, representing us, that you're going to be the body that helps us with that. So,
Thank you.
okay, thank you.